Thank you. We have both counsel here today. Mr. Shimkus, I believe you represent the appellant. Did you wish to reserve any time?
Yes, Judge. 3 minutes, please.
Okay, I will try to appropriately interrupt your proceeding to let you know as you approach that moment.
Thank you.
You may proceed.
Your Honors, may it please the court and counsel. Your Honors, I'm excited today to present an issue that I believe is one of first impression in Florida, and that is what is the legal effect when a contract is incorporated but not merged into a final judgment of dissolution as it relates to the statute of limitations applicable to a subsequent enforcement action. What we'll see is that in this case, the facts aren't that complicated. The parties entered into an MSA back in 1997. They then, in that MSA, they have it declared that it shall be incorporated, but that its incorporation not cancel or void any of the terms contained in the contract. In their answer brief, former wife readily concedes the point that this contract was intended to survive incorporation. That's included in their answer brief, page 13. So I don't believe that there's any contention today that we are dealing with a merged instrument. I believe everyone at least concedes that we are dealing with a non-merged instrument. So what happened was that the judgment of divorce was entered back in April of 97. Within the MSA itself, there was an obligation to do a certain thing. Former husband was obligated to pay back a loan to former wife in the magnitude of $487,060. And former husband had two options to do so. He could make one lump sum payment by January 1st of 2001, or he could make 5 annual installment payments, with the last one falling on December 31st, 2005. There's no contention that former husband failed to make any payment whatsoever, and that's readily conceded. That is a fact. The real question here is, when former wife decided to enforce her rights under that agreement, but when she didn't file a motion until essentially at least 11 years after the last date of default, is her motion to enforce time barred by the statute of limitations applicable to contracts? That is, in essence, what this appeal is for. So, Your Honors, again, the position that we've taken consistently throughout this case is that there truly is no Florida precedent addressing this question, the effect that non-merger has on the applicable statute of limitations. Now, former wife, for her part, has insisted vigorously and repeatedly that there is, and that this is not an issue of first impression. But every time former wife presents her case law for that proposition, you will find that in every single case cited by former wife, there is a complete absence of any discussion or recognition that non-merger played any kind of a role in those cases. So I would maintain to this court, it remains an issue that's been unresolved by any appellate court of Florida. So in the absence of direction on what should happen and which statute of limitations should apply to this action, I believe it's incumbent upon this court to consider what sister states have done. And so we've presented to this court, both in the initial brief and then in the reply brief, at least 4 different examples of sister states ruling.
To just kind of fast forward ahead just a little bit, both sides have presented cases from other jurisdictions, and what I would be interested in is your thoughts as to kind of the first principle or underlying premise of what these holdings, to the holdings that you have marshaled that say that, hey, if it's not merged out of its existence, then therefore that must be what's being enforced. It raises a question: why can't an agreement continue to have its own legal existence because it hasn't been merged, and that a final judgment incorporating that instrument is capable of being enforced qua final judgment, which is exactly what the title of this motion enforcement said it was doing: motion to enforce final judgment. Why is the absence of why does merger matter in terms of enforcing a final judgment when it incorporates a marital settlement agreement?
I think there's 2 ways that question can be addressed. I think one is by looking at why these other four sister states have ruled the way that they have in
Well,
applying.
I tell you, so I've got it in front of me. The Arkansas case that just doesn't address it. It just assumes that, well, you know, we know that merger gets rid of the instrument, so therefore, since I can't even look at it, it must be the final judgment by default that's being enforced, but doesn't consider the other step, which is that, well, just because you have both there doesn't mean that you're pigeonholed into enforcing only the contract.
Sure.
At least the Arkansas case doesn't even address that.
So I believe the other cases reason that when this happens, and these are the facts, that there's non-merger, but there's incorporation by reference, essentially, that when the substance of the enforcement action is found in the contract itself, and I believe these other cases will say it just before they reach their holding, that it is a contract, right? That the substance is contained in a contract. And so the principles of contract law ought to govern to the exclusion of any other.
Why?
I can't tell you that they
Yeah,
have
exactly. Ought is a wonderful word because it can pull on so many different strings without anybody ever realizing what strings are being pulled. And that's why I'm questioning the authorities of you, Marshall, because well, it ought to be, but nobody ever tells me why. Well, why do we have to now ignore the fact that these parties expressly agreed to incorporate into a final judgment with all the ramifications that holds? They expressly agreed to incorporate that into a final judgment. Or let me say it this way. I'm reading now from the Peabody case. Tell me why this is wrong. All right, here's what the Michigan court says. When the parties to a divorce agree through their attorneys to incorporate the terms of a property settlement agreement by reference and specifically agree not to merge the agreement into a judgment, that's what we have here, it could be assumed that the attorneys in the court that enters the judgment understand the definitions of merger and incorporation by reference. The clear intent of parties entering into such an agreement would be to make the agreement enforceable both as a court order and as an ordinary contract. What is wrong or incorrect with that analysis?
I think it's the same criticism that you just raised with respect to the other three opinions in different states. There's no explanation as to why it should be assumed.
Sure, I'll give it to you right. It's front and center because you have these two instruments. You have them both, and they were not merged. You have the conundrum of which one is it that's being enforced because A has a statute of limitations in this case for 20 years. B has statute of limitations for 5 years. Because they both have an existence, you have to decide one of them applies. The answer is, well, the logical conclusion of B not being merged means that it's still there. So I have a choice because they are both presented in front of me. To me, there's an intuitive appeal to that.
Well,
as opposed to saying, well, because it didn't merge, you now must ignore it, which has no intuitive logic to it. Just because it got merged doesn't mean that the other one somehow goes away.
Well, here's some intuitive logic, if I may. Where we have incorporation essentially by reference without extinguishing the underlying contract, what we're saying is, here's the judgment of divorce. And if you want to see what the terms are that ought to be enforced, look over here to this other document, right?
Okay.
Well, what happens when that reference point, i.e. the other document, ceases to be enforceable because of its own independent statute of limitations? Then that document essentially disappears as far as the reference goes, and you've got a judgment which is referring to essentially unenforceable provisions. Now, that's one way of looking at the nexus between the two. You've taken the legs out from underneath the table after 5 years.
Yeah, but I'm not sure that aligns with what the commonly accepted understanding of what incorporation means. Incorporation does not ordinarily mean that you annihilate the instrument that states you are incorporating something else. Rather, it usually means that they're construed together. Not a merger, you're not getting rid of something, but that they're construed in tandem. So well, I'm not sure that gets you there.
Well, respectfully, Your Honor, I believe that in the absence of non-merger language, merger is the default effect of incorporation. So I believe you and I just have a different conception of what just plain incorporation results in. And I might be wrong, but that's my understanding of the law of incorporation.
Okay.
Another thing to consider is if we accept the proposition that there's no Florida binding precedent on this specific question, and while we recognize that there may be 3 or 4 different sister states finding that the statute of limitations for contracts would apply. And maybe we only are aware that one in Michigan, Peabody, takes the opposite position. And this court is being asked to, in a way, choose sides. Although it's tempting to say the court should follow the majority and leave it at that, that's obviously not persuasive. So let's consider policy reasons why the court may want to align itself with the majority of sister states. I think what we find is that there's 2 strong purposes for that. A, remaining consistent to the law governing contracts. Again, if the parties, if the source of the provisions governing the parties emanates by a negotiated instrument in a marital settlement agreement, the origin of this entire sequence of events is a contract, and it remains a contract when there's non-merger. And so if we're going to acknowledge the fact that the source emanates from a contract, that the contract remains a contract, we ought to be consistent in the law that we apply when someone seeks to enforce its terms. And one way of doing so would be to restrict the analysis to contract law. Now, another consideration is, what is one of the policy objectives of Florida as it relates to divorcing couples? I would submit to this court that one of the policy initiatives is to sever ties, to disentangle the lives of 2 acrimonious former spouses. We see that done in areas governing whether or not divorced parties should be entitled to continue to remain as business owners from a family business. We decry that, right, as not serving a good purpose. We see hints of this when we have rules that set intended timelines for resolving contested dissolution of marriage cases at 180 days. We see this embracing of limiting litigation as it relates to making changes to support or custody issues when the movement has to satisfy an extraordinary burden of proving a substantial change. What we see throughout all of this is that there are important reasons to limit the opportunity for litigation and to allow these parties to move on with their respective lives. Embracing the Peabody line, or the Peabody case as it were, would in essence say, we want a spouse who believes they've been aggrieved to have at least 20 years to drag the ex-spouse back into court and reinstitute litigation. I would submit to this court that is not a policy that benefits the divorcing spouses in Florida as a whole. I believe that the citizens of Florida want to have their issues remedied as soon as they can be.
Does it violate the public policy of the state of Florida for them to contract differently?
With respect to what, Your Honor?
To have it incorporated and not merged. If they wish to have it available in 2 forums, is there anything in the public policy of the state of Florida that would bar such a contract?
No, absolutely not. But I would submit that the impact of that is that so long as the statute of limitations for the underlying fundamental document, that is the agreement, have not expired, then Your Honors are absolutely correct. A person, an aggrieved claimant, has the right to bring an enforcement of the judgment claim, as well as an enforcement of the contract or a breach of contract claim. But I would submit that once that contract statute of limitations has run, the entire building or the relationship between the 2 collapses. And that results in a preferred result, which is limiting the timeline that these parties can drag each other into court.
Here's the thing, though, and I'm going with you on this argument, except yes, a marital settlement agreement is a contract, but what is it that is being resolved here? It's equitable distribution, right? It's a property settlement. And that is uniquely statutory. The very premise of the contract is, how are we going to dispose of marital assets pursuant to what the trial court would have to do under Florida statute. So it's not like these are folks. The analogy to contract with an MSA is certainly understandable. We say that they're interpreted in accordance with contract terms all the time, but MSAs they're a little bit almost like construing insurance policies. Yes, we say that there's insurance policies are construed under contract law, but there's this whole host of special things that we do whenever we construe insurance policies. Couldn't the same argument be said about marital settlement agreements? And that since, these are not this is not really a true, two strangers coming together and agreeing how to divvy up a former debt or how to divvy up a business. Rather, this is a husband and wife whose marriage is being dissolved. Pursuant to Florida statute, the trial court is charged with equitably distributing their assets and debts, and they have agreed how that is going to be divvied up. The final judgment reflects that agreement, but the essence of it is to reflect an equitable distribution, right? Which is part and parcel of the final judgment. So on the one hand, I see what you're saying about, well, it came about because of an MSA, so therefore treat it like a contract, because that's really what they're enforcing. But then if you peel the onion back another layer, you say, well, yeah, but what was it that the MSA was agreeing to? It was agreeing to an equitable distribution, which is inherently a part of the final judgment that the family court makes. Help me out with that.
As you respond, you are at just past 15 and a half.
Well, thank
I know you went to reserve 3, but I try to give you a warning at a good spot before you start. Is a good spot.
Okay, thank you. So, Your Honor, I've heard you, but I can't say that I entirely follow the holdup. Whether we characterize it as an equitable distribution award or not, as far as I can tell, it's an obligation that a party obligated himself to perform pursuant to a contract. And so I would fall back on my original argument. I don't know how calling it an equitable distribution award changes the analysis.
Mr. Shimkus, okay,
yes.
So accepting your argument. So in essence, though, aren't we discouraging parties from entering into marital settlement agreements? So why wouldn't they just have the trial court do this so that they could enforce the final judgment on these issues for 20 years as opposed to being stuck with the statute of limitation of contract law? So
I don't.
So here, where the parties, and I think this is what Judge Castanueva was getting at, is that where the parties have agreed to the core issues that the trial court has to decide, and they've agreed to have it incorporated into the final judgment. Not only that, but also enforced. That's what the parties agreed to. They certainly didn't have to agree to that. If your client didn't want to agree, oh, okay, well, I don't want to have to be subject to a 20-year enforcement on these issues, then certainly your client didn't have to. But that's what the parties agreed to do.
So a couple things. First, presuming that the intent of the parties was that this would be enforceable for 20 years, I think is a big assumption. Because as
the law says. That's what the law says.
Well, I would submit to this court, that's not what the law says when there's non-merger language in a contract that's incorporated.
Well, outside of Florida.
Outside of Florida, with respect to which state?
You're relying on cases outside of Florida.
Yes, Your Honor.
That proposition.
Yes, correct. But as to, why parties would do this, if my position is adopted by the court, why would that benefit the parties? It would benefit them in the following way. For one, it would ensure that the window of time that either party could sue the other is limited, which I believe is a benefit to the parties in that they can achieve closure sooner. But more than that, by electing non-merger and adopting this approach through negotiation,
but you're asking the court to enter, but okay, so what you're asking though is for the court to interject language into, because these settlement agreements, they can do more than what a court can do, correct?
Correct.
And the case law shows that in addition to that, courts can enforce things that they wouldn't necessarily be able to award parties where the parties have agreed to certain terms in the marital settlement agreement. So anyway, I think your argument is trying to inject language and inject terms onto parties where they may not necessarily agree. Certainly the parties here could have agreed, hey, that as far as this payment, if you don't enforce it, or if you don't seek enforcement within so many years, then, you know, you've waived it. I mean, I think these are certainly terms that the parties could have come up with themselves if you wanted some sort of closure within a certain period of time.
So if the contention is that the parties intended for this result, I would simply respond the way I did last time, which is, I don't believe that that is evident on the face of the document, that the parties had both agreed that this should be enforceable for 20 years. I believe that they agreed it should survive incorporation. And what that means, I believe the state of Florida has been silent on so far. And so that's why this argument is now being presented for, I believe, the first time. And I believe that there's important policy reasons for closure, for fidelity to the law of contracts, as to why this court should align itself with the majority of sister states on this issue.
You probably need to stop
Judge
at the time past 20 minutes.
All right, but before I just to say,
You
I had
want
other
rebuttal
arguments.
time, or do you want to keep going?
No, I'd like rebuttal time. I just want to rely on the remaining arguments of the brief.
On your
Thank
brief,
you.
that's fine. I well understand that. Thank you, sir. Okay. Okay. Mr. Hall, I believe is your opportunity to respond.
May it please the court. Parker Hall, Christopher Owen Hall, on behalf of the appellee Peggy Webb. It's important here to start with the actual language in the parties' settlement agreement and final judgment of dissolution of marriage. When you look at paragraph 4, page 5 of the actual agreement, it states in the relevant part that the parties shall have the authority and power to incorporate in any final decree or judgment entered in such cause the provisions of this agreement in their entirety. The agreement shall be and become part of any such final decree entered in such cause. This is exactly what happened here. The parties intended their agreement be incorporated and made part of a final judgment. By including this language, it evidences the intent that specific provisions of the agreement survive incorporation and that those provisions become part of the judgment. So then if you move to the final judgment in this case, you'll see in paragraph 2, it states that the agreement is approved and incorporated into this judgment by reference and fully as if set forth herein, and the parties are ordered to comply with same. So we have a final judgment here and a settlement agreement, which contain express language of incorporation that the parties are ordered to comply with same. We argue, and the lower court found in this case, that when a judgment approves a settlement agreement and expressly incorporates it by reference, or includes a provision directing that both parties perform all of its terms, it is the equivalent of a judgment containing the same terms as the agreement. Incorporation of an agreement elevates the agreement to the dignity and effect of a court decree. But let's back up and look at a general divorce case. When a spouse enters into a settlement agreement with another spouse, at that point, it's just a contract, a general contract, which they'd have to bring in enforcement on under contract law for breach. The parties could go forward, get a final judgment on an uncontested basis, merely dissolving their marriage. But what the parties do, including the Webbs in this case, is ask the court to incorporate that agreement in the final judgment. They do this because they want the terms of the agreement in a final judgment so it can be enforced by the court. The court goes a step further by retaining jurisdiction to do just that. So unlike a breach of contract action that requires a plaintiff to first prove an enforceable contract, offer acceptance consideration, the ex-spouse merely has to point to the divorce judgment. The trial court was correct here as a matter of law in finding that Florida Statute 95.111, the 20-year statute of limitations, was applicable to enforcement of a marital settlement agreement that was incorporated into a final judgment of dissolution of marriage. So addressing the issue of merger and non-merger language, the former husband argues on appeal that the question here is what effect non-merger language has on the statute of limitations applicable to a contract that is subsequently incorporated into a final judgment. In this case, we have an express provision for incorporation, but there's no express provision or language of merger or non-merger. For all of the former husband's arguments, he's relying on paragraph 4, page 3 of the agreement, which states inclusion of the provisions in this agreement and any such interlocutory or final decree or judgment entered in a cause as hereby described shall not cancel, void, or in any way evade the terms of this agreement. So former husband is labeling that language as non-merger language. We argue that it does not, but is language that further supports our position that all the terms of the agreement were incorporated into the final judgment. For example, shall not cancel, shall not void. This shows the party's intent that the terms become part of the final judgment and enforced as though. What counsel is doing is labeling this language as a prohibition of merger. He's elevating the language in the agreement and calling it a non-merger provision. Merger is not mentioned anywhere in either document and is not relevant to the documents at issue in this case. So former husband cite, moving on to Florida case law. The former husband cites no Florida cases for his position. Although there are no Florida cases directly on point to this issue, we cite Florida cases that infer or illustrate that incorporated agreement should be treated as a judgment and support the fact that a 20-year statute of limitations should apply.
Well, those cases, I don't have the names of the cases in front of me. What was a statute of limitations defense even raised in those cases? Or is it just you look at the timeline of when the enforcement action was entered and when the judgment was entered, and that's your inference?
So, for example, the case we cited out of this court, Your Honor, the Second District Court of Appeal, it doesn't address the statute of limitations, but what is relevant is an agreement was incorporated into a final judgment, and a former wife was entitled to seek enforcement some 11 years later.
Right. So the answer to my question is the second. You basically, you took the timelines of these cases and said, oh, look, they enforced it beyond statute of limitations. It doesn't mean that the issue is before us, because statute of limitations is an affirmative defense that has to be raised.
Yes, Your
So
Honor.
if it hasn't been raised, we're not deciding it.
Yes, Your Honor. We can see that there's no cases directly on point from Florida,
Okay.
but we just we cite these cases to maybe infer or illustrate that what would occur if it was. And for example, we cite to a case, Creniglia out of the Supreme Court of Florida. And this is a case where the wife brought an action for duress and sought to set aside an agreement based on fraud of the court. And it was an agreement that was incorporated into a final judgment of dissolution of marriage. The court found that in doing so, it amounted to an attack on the final judgment itself based on duress and was subject to the 1-year statute of limitations. The reason we cite this case is to kind of show the similarities between what happened here and the statute of limitations issue in our case.
Which case was that again, counsel?
Creniglia v. Creniglia out of the Supreme Court of Florida. So this court cites to Florida Rule Civil Procedure 1.540B, which applies where a party seeks relief from a judgment, decree, order, or other proceeding. So the court did not apply a 5-year statute of limitations when reviewing this contract. So we kind of just cite this case to show the similarities that they treated the fraud on the agreement as part of fraud in the court and the final judgment itself, to try to pull a similarity there. The language is also similar to Florida Statute 95.11, judgment, decree, order between those two statutes. So we're trying to pull an analogy on how the court would treat this issue. Moving to cases from other jurisdictions, the former husband argues that there are no Florida cases dealing with merger and non-merger language. These cases cited by the former husband, including from this court, we argue, illustrate, and infer that an agreement incorporated into a final judgment is enforced as a judgment. The former husband in his brief relies on Arkansas cases which state the statute of limitations applicable to general contracts to an incorporated but not merged agreement applies. These Arkansas cases do not accurately rely on Florida law and have no controlling presidential value on the issue of appeal, which is why we tried to pull some cases that illustrate from Florida to support our position. And on the brief, the former husband continues to rely on cases from Arizona, Pennsylvania, and Oklahoma. In our brief, we cite cases from Michigan, Texas, and Mississippi. So the main point I'm trying to make here is that the parties could likely go back and forth on cases from other jurisdictions to support their position. And like counsel and like Your Honor pointed out earlier, is we would like to draw attention to that Michigan Court of Appeal case, Peabody versus D. Meglio. Specifically because if the court were to rule that there was some sort of merger or non-merger language in these two documents, this case seems to have the best analysis of a definition of incorporation by reference compared to merger. It defines incorporation by reference to mean a method of making a secondary document, marital settlement agreement, part of a primary document, final judgment of dissolution of marriage, by including in the primary document a statement that the secondary document will be treated as if it were contained in the primary one. So the terms of the agreement, the judgment is treated as if the terms of the agreement are actually included within it. It defines merger as the absorption of a contract into a court order so that the agreement between the parties loses its separate identity as an enforceable contract when it is incorporated into a court order. And they looked really at the parties' intent here on choosing one language over another, and they concluded that the clear intent of parties entering into an agreement that would specifically incorporate by reference, but not merge within the judgment, would be to make the agreement enforceable as a court order and as an ordinary contract, giving the parties the choice. Here, it's clear that the former wife brought the action based on to enforce the judgment and not breach of contract. So if the court is going to rely on a case from another jurisdiction, we ask that this would be the one that presents the best analysis of the different languages that are included in the two different documents, the settlement agreement and the final judgment of dissolution of marriage. I'd like to point to the issue. I want to bring up an issue, which is the contractual rate of interest that's included within the judgment. So Florida Statute 55.03 generally does provide that payment of statutory interest is rate applicable to judgments applies to a judgment. However, the same statute also provides that nothing contained herein shall affect the rate established by written contract or obligation. At this point, this is where we think the same language that's relied on for non-merger and merger language comes into play. It had that provision and relevant part saying that incorporating the agreement into the final judgment shall not cancel, void, or in any way evade the terms of the agreement. So this language is clear here and becomes relevant, and it's clear from that the parties intended to preserve the contractual interest rate after incorporation of the agreement into the final judgment. So that's where we believe that language of the agreement comes in, not as non-merger language, but as a general contract term to say that it survives and we want all these terms to be enforced within the final judgment itself.
Counsel, you need to tell me, since we're so far apart, whether you have concluded. I'm not going to interrupt you otherwise.
Okay, Your Honor, I just have one more issue, which is the second issue on appeal, which is, I'm sorry, Your Honor, did you say I'm out of time?
No, sir, I just said,
Okay.
if you were waiting for me to say thank you, move on, I'm not going to do it till you tell me you're done.
Oh,
I'm
thank you so much.
not going to be presumptuous.
Okay, thank you so much. I'll move on to the second issue on appeal, which is the attorney's fees issue. The trial court order and amended final judgment on fees, we argue is non-final. It's a non-determination, not yet ripe for appellate review, as it only determines entitlement to fees here. An order that only determines the entitlement to attorney's fees without setting the amount is non-appealable. It's not final yet, and the lower court must determine the amount of the award first, or else we will be right back here after the amount is determined. So unless the court has any further questions, I rely on the answer brief for any further argument. In conclusion, we ask that this court affirm the amended final judgment on order granting former wife's sworn motion to enforce the final judgment. Thank you so much.
Thank you, counsel. Counsel, normally I would probably tell a rebuttal that you went past 20 and your time was used up. But, you know, your opposing counsel was kind enough to leave us a little time. Plus, we took up a lot of your time, so I'm going to use, what is it called? My sound discretion. And I know my panel members may chuckle at that, thinking that I have sound discretion. But anyway, we'll give you 2 more minutes.
Thank you, Your Honor. Very quickly, the contention that there is not non-merger language in this contract, I believe, is belied by several things, not least of which is the appellee's representation in the answer brief that the contract should survive incorporation. I believe that's only capable of occurring when there has been no merger. So I'd maintain that both parties have, during the course of this case, acknowledged that non-merger is a factor. Now, I think the interest rate argument is an interesting one because, sure enough, Section 55.03 does provide that the parties may dictate the interest rate applicable to a contract, and it also leaves the door open for that interest rate to be applied to the resulting judgment. However, as interpreted by the Supreme Court of Florida in the case of Whitehurst, which is in our brief, that can only be so when the contract expressly provides that its contract interest rate should apply to post-judgment. Only. That is the only way that that can occur. There is nothing in the contract in this case that provides that for a contractual interest rate to apply post-judgment. And so what happens was if former wife is going to be consistent and faithful to the law of 55.03, that contractual interest rate would only have existed from the date of entry of the MSA to the original divorce decree in 1997. Beyond that, it would have been statutory interest rate, but that's not what she asked for.
How do we have jurisdiction to review this part of the judgment? How do we have jurisdiction?
How do you have jurisdiction?
Yeah, do we have an actual amount of attorney's fees that's been decided yet?
Your Honor, I'm responding to the interest rate argument, not the entitlement to attorney's
Oh,
fees.
I'm sorry. I was thinking of something else. I was thinking of the other point in this. So on the interest rate, what you were saying is that there was an incorrect or the argument is there's an incorrect calculation based upon the method used. And I think in this one, it was prime plus 1.
Correct. Former wife wants to come to court now and claim that she had a judgment from 97 and it's existed all this time. And yet she's coming to court asking for an inconsistent remedy with that. The remedy she's asking for is that she be awarded contractual interest on that, which would have expired had 1997 resulted in a judgment. And Whitehurst says that the only way you can apply contractual interest rate beyond the judgment date is if the parties expressly provide for post-judgment application. And that didn't occur here. So this is evidence that former wife's intent, she wasn't dealing with a judgment, she was dealing with a contract. And the first time she came to have that contract reduced to judgment may well have been in 2017. So I would love to respond to the entitlement to attorney's fees if Your Honor wants me to, but I realize I've exceeded my time.
No, I've already used up a lot of your time, counsel. Thank you.
I thank you all. We have expired as that time. Fortunately, we're all still above ground, so that's it. Thank you for joining us today. I guess I have to ask you to exit, however you do that, this room or whatever this place is, and we're going to be closing down. Stay well, stay safe.
Thank you, Your Honors.
Thank you.